Good evening, everyone, and welcome to another edition of our Justice and Pieces series here. Today, we are joined by Farhad and Sansia. So, first of all, thank you, both of you, for taking the time to speak with me and speak with our students here. So, perhaps maybe we'll start with you, Farhad. Maybe you can tell us a little bit about yourself, your practice, and your firm, and then we'll go over to you, Sansia, right after.
Thank you. Pleasure to be here. So we have a pretty diverse practice. I would say half is employment law, 50%, and the other 50% is general litigation, ranging from real estate disputes to business disputes, insurance matters, tribunal litigation. So we keep busy. Sansia, do you want to add to that?
Yeah, I mean, I think Fahad covered it quite well. I think also our backgrounds are quite varied from, being called to the bar to our current years of practice. And so that's why on the general civil lit side, there's a lot of intersecting. And so we do end up picking up, the real estate litigation files. And then, of course, we have like the landlord disputes, commercial disputes, which keeps things interesting. But the bulk of our practice, like Farhad said, is definitely employment related. We also do appear at several professional discipline colleges as well. So we do quite a bit of tribunal litigation, and then of course, EI appeals related to employment, etc. We enjoy it. It keeps us busy. Farhan and I enjoy anything litigation. So at Pinto Shekib, we're always ready to go, I suppose.
Well, that's great. And I think, you mentioned certainly employment being the bulk of it. So maybe we'll start kind of there. And Farhad, maybe you could kind of tell me, I think, you mentioned earlier that, that you do both employer and employee side. So let's, I'll paint you a scenario, typical, unfortunately these days, right, is someone comes to you and said, I just got this, letter of termination from my employer. They are telling me that I've been there for how many years, that I get 4 weeks notice, and then they just said don't come in next Monday, and they're going to pay me that 4 weeks, and let's say they've been employed, I don't know, like 10 years there, whatever corresponds to the ESA minimums, and so maybe you can kind of walk through what that process is like when they arrive at the firm, and how everything goes.
Well, sure. So the first step is you have a consultation. We look at your employment contract. If there is a contract, we look at a termination clause. Oftentimes, there's a 95% chance that those clauses are not valid. The law changes so much in the employment arena, that within weeks or months, you may have new cases that could render, a lot of these contracts invalid. So we see if that clause is invalid, and if it is, then they're entitled to common law notice, generally speaking. So in that case, if you've been there for 10 years and, let's say you're in your 40s or 50s and you make a six-figure salary, your common law could be 10 months, it could be 12 months, it could be 15 months. We've gotten one particular case, for example, we've got an employee who was there for, I think, a year. She was 54, making 120 grand. And I think we got her 8 months or 9 months, subject to allocation. So there's no formula, or like there's no formula that says if you're there for X, you get Y. There's a lot of factors that go into it. You got to see the age, the length of service, mitigation, likelihood of reemployment, mental health challenges that may make reemployment more challenging. So you factor those things into account, and I would say 80 to 90% of these cases will settle. So yeah, you look at the contract and then you give them your opinion, and then you ask them, look, what is the likelihood of mitigation? So how likely are you to find comparable employment within the next 3 months, 4 months, 6 months? And generally speaking, the older they are, the more specialized the role, the more money they earn, it's going to be harder to find comparable employment. But oftentimes, some people are very employable and they'll tell me I can find a job in a month, 2 months, 3 months. In that case, you may want to just consider negotiating early on, avoiding litigation and just getting what you can get if you think your mitigation chances are high. But if it's going to be tough, then we sue, and then we take it from there. But most of these cases will settle, like 95, 96% will settle.
So on that point, I mean, when you make that first step, then let's say they've retained you, they're obviously well, hopefully they're looking. I think, maybe you're going to, you mentioned mitigation. Maybe you're telling them, hey, keep a journal that you're actually
Right.
going and applying, and you're not on, Dominican cruises and stuff. And just thinking, I can't find a job. Wonder why, right? But
Right.
what else is kind of in that process before you decide, okay, I think maybe we have to file, either superior court, or small claims court, I guess, potentially if it's a really small kind
Yeah.
of matter. But and then what happens after that?
So look, you got to you got to talk to your client and be honest. Most of these cases settle. The problem is that there's a lot of delays now in the courts. You have crazy backlog. Judges are not giving you dates for motions. Like summary judgment dates are getting very hard to get. And so you try to have a frank discussion and see whether this case is worth litigating and to what point. Oftentimes, the cases we get, we're very fortunate. They tend to be great cases. I mean, people are earning 100 grand, 200 grand. They've been there for 10, 15, 20 years. And employers often shortchange them, almost always shortchange them. So there's a lot of, you're fighting often over 2, 3, 400 grand, plus aggravated damages, plus, a bunch of other things. So that becomes a fight. The employers don't like to pay out that kind of money right away. So we often do end up suing. But sometimes we've had cases where people have come to us and said, look, you know, I, I'm pretty sure I'll have a job lined up in a month and I can make as much money as these guys were offering me before. So what can you get me? In that case, I'll come in, I'll negotiate. I might be able to get them a good chunk of change, and then they're on their way and they've got a new job already. So it really does vary. But the process is you issue a claim, a defense comes in, 90% of the time you go to a mediation, and that's the end of it. And that's how it should be. I'm also on the employer side at times, and sometimes you get employers with a very deep pocket and they have an axe to grind and they want to drag it out, and sometimes they have good defensible cases. But generally speaking, claim defense, mediation, and cases settle.
So something maybe you can tell us a little bit more on the employer side. So they come to you, well, hey, I've received, well, obviously not from Farhad, but I've received a statement of claim, from an employment lawyer who is saying, my termination clause was vague. I thought, I had it covered. I'm giving them 4 weeks. No, that's what the ESA says. No, 3. I gave them 4.
Right.
Why? They didn't even go to work those 4 weeks. They got this free money. Aren't I, so great? Why am I getting sued? What could happen? So what happens on that side, Sansia?
JP, you must know a lot of these employer clients because they all think they get such a good deal. So let me tell you, there's 2 aspects to speak about on the employer side. So one is what you just raised, and then the other aspect I'd like to touch on just briefly is the investigation side of it, because employers come to us for a lot of that advice as well. But let's start with the first one that you raised, which is a great one. So, typically a lot of employers, they maybe consulted counsel sometimes years before. Okay. They've got some employment contract that they drafted, which every year, if not every other month, the courts are constantly changing things and disallowing all kinds of things in these drafted contracts. And so these employers, they really put so much weight to that, right? Because it's like, no, but I got a lawyer back 6 years ago, gave me this contract, and we relied on it. And the contract says I just have to pay this, and I even gave an extra week or 2. And so, we always try to kind of give them practical advice, right? So some cases, and Fahad kind of mentioned, they're defensible, right? And if they're defensible, you tell the client that, but you also want to give them the full picture. While something may be defensible, just think about how much money you're going to be bleeding through the litigation process. What are we looking at here, right? So we always want to evaluate what the other side is asking for. So what plaintiff's counsel is asking for, take a look at, what our clients would be spending out of pocket. Obviously, do they even have a case, right? Is the contract problematic? Is the termination clause problematic? And so depending on what the scenario is, right, we would recommend obviously making counter offers, right? So sometimes we get these before claim, which is like the demand letter stage kind of that Fahad sort of alluded to, and that's pre-litigation. So sometimes you can stop the bleeding really quick, JP, and do your client a big favor. Other times, counsel has already issued the claim. We got the claim, we got 20 days to put in the defense. I have to get their version of what happened. And sometimes you put in the defense and then you have some informal discussions, and other times you go straight to mediation or discoveries, depending on whether it was for cause, without cause, So it's very fact specific, but we always try to advise employer clients and even our plaintiff clients, just on both sides, to try and be, conscious of costs and delays in the courts, right? Because Fahad mentioned this before. You may have a great case to litigate, and Fahad will tell you, about a case, or I can tell you about it was on the plaintiff side. Great case to litigate, but it's going to take years to get a decision, and some clients just either can't wait or they can't deal with the stress of court. So, you want to advise your employer and employee clients in a specific way, right? Because it's got to be tailored service, because what's good for one employer may not be good for the other. Same with one plaintiff over another, right? And then you have the other aspect, which is what Fahad and I both do, is that you'll have an employer client who will come to you for investigation. So it could be sexual harassment in the workplace. It could be an allegation of toxic work environment, harassment. And so, like I was on a call just about last week, actually, with one of our employer clients, and we're basically like their form of sort of in-house counsel. So all their matters come to us, whether it's investigation, termination, policies, all that good stuff, right? And so they came to us specifically for advice because, for example, an employee is raising, for example, harassment in the workplace or toxic work environment. How do we deal with this? So we'll help them in terms of framing what their obligations are, what they're required to do, and how to conduct that investigation fairly, and whether it should be conducted by HR or it needs to be conducted by somebody independent and outside. And so throughout that process, we'll advise them. Sometimes they'll send us even the correspondence, say, hey, Fahad or Sansa, can you look at this before we send it out? We've concluded that investigation. This is what we'd like to put on there. Most of the time, I'll tell you, JP, I'm editing that thing like crazy, because they put a lot of stuff that I'm just thinking litigation. My head is like litigation. So I'm just like, clean that up. No, maybe just say it was inappropriate. Take out this word, take out that word, right? So we advise them in terms of how to conduct an investigation. Sometimes we have to do the investigation ourselves, or we end up telling them to get a third-party investigator, right? And then we assist them with the final drafting, usually, of what the conclusion of that investigation is and any steps that are going to be taken and any recommendations. And so, it can be a wide scope of what you can do on the employer side, in addition to, of course, drafting of policies, contracts, all that good stuff. Brad, did you want to add anything? Did I miss?
Sometimes the employers and the companies take a very principled approach, and they'll spend a lot more money on legal fees to send a message that, they will defend claims that they view are frivolous or meritless. So sometimes it ends up being a trial, and they will not settle those type of cases.
Okay, so let's kind of look at it then. The other thing on that you may encounter is what happens when they do kind of posture about doing something, right? As Sansia mentioned, do you have to kind of force the hand by filing the claim, because then that kind of gives them a choice? Okay, well, either got to defend, in 20 days to respond, or we got to settle. Like, do you find that there's a lot of, we don't need to do anything until you actually go from the demand letter to a claim being filed?
Sorry, who do you want to answer this one?
I guess you could start with it, Farhad.
Sure. Yes, 100%, because on the employer side, the delay favors the employer generally. It gives more time for the employee to mitigate. The courts are very much backlogged. So what we do is we generally issue a claim, and while we're happy to have discussions once the claim has been issued, we now just set procedural timelines in place for all our cases, employment or otherwise. Discovery, mediation, all those have to get scheduled, and we're happy to have discussions in between. Otherwise, what we've found in the past is you can spend months going back and forth, and then nothing has happened. No negotiations are not successful, and you haven't moved the case forward. So when you have a threat of a motion or of legal fees being incurred, I find that it makes both parties act more reasonably. I mean, Sansa, what do you think?
Yeah, no, I have to agree with Fahad, right? Sometimes, the demand letter, depending on the employer, may or may not do anything, right? Litigation, obviously, everyone's spending money. There's timelines, there's dismissals, there's so many things to consider. And things get more expensive. When you're dealing at the demand letter phase, things are a lot cheaper. It's conversations between counsel, maybe a Zoom meeting here and there, and the rest are some demand letters going back and forth. But once you're in litigation, there's expensive procedural steps. So people I mean, employer and employee, they take things way more seriously. But on the employer side, it's to their benefit to slow things down. They're not looking to push it. Let the plaintiff do what they want. If the plaintiff's going to take forever, I'm just going to sit back and relax, right? Because I want to see, are they going to get a job, for example, if it's the employment context, right? And if they do, then I get a credit for that. So I'm not looking to rush the case. So the best way to deal with something like that, if you're on the employee side, is say, look, we can have whatever discussions you want to have or clarifications of evidence, information. However, we need to set all procedural timelines. There's no prejudice to any party to continue all the settlement discussions you like, so long as the timelines are in place. And this way, there's no delay. You move it. You move the file. You got to push.
Now, once they kind of come to an agreement, is that essentially it? Against maybe Farhad, like, do you need to sort of, advise, the client on, other, maybe tax implications? I think I felt that there was something recently about how things are structured sometimes, and hopefully you can jump in there and help sort out what I may have come across about something like that, where if there's a settlement, like, you're still got to report it, right? Farhad, I don't know, maybe you can tell me, what are some of the, after they've reached an agreement and it settles, what's next?
So as part of the settlement, you do often discuss allocation. So as you may know, income that you get from the employer is taxable, but if you allocate it to, say, general damages, that's non-taxable. A lot of employers don't like general damages. The settlements are often, and you settle without admitting liability. So that's in the minutes. We put it in there. Neither party admits liability, etc. But oftentimes you can say it's 100 grand. You can put, say, 30 grand to damages, 40 to an RSP, 30 to income, and you can work around with it to make it more tax efficient. But you have to have a good faith basis for the damages claim as well. So there has to be something in the pleadings and in the evidence, medical records, doctor's notes, something to substantiate that claim. And the CRA did pass something that talked about having to report, allocations of settlement, etc. But I think they've backed down now. I mean, Sansia, do you recall? I think there's an injunction or.
Yeah, I think at this point, obviously, there was some chatter about, what employment lawyers or lawyers in general have to report and not report. And for now, it seems to be that, we're not really obligated to provide that information because obviously for privilege purposes and so many other reasons, it would be highly problematic. But what Fahad said is still important, though, regardless of that whole CRA scuffle that came up, is if you are going to be allocating something to general damages, there has to be some reasonable basis to it, whether it's in the pleadings or medical records that support something that would warrant general damages, right? So it does still happen a lot. Obviously, general damage is a big part of employment matters, and it's just about making sure that things are structured in the settlement that is A, efficient for your client, but B, that there's a basis for the way things are structured.
Yeah, and one of the other things you talked about, was on the investigative side, but like, is there ever a situation where perhaps, someone is either the complainant, right, and they want to know, like, what are my rights in the situation, or maybe someone, there may be an investigation about some of their conduct, not necessarily, as you mentioned, the employer comes to you, how do I word this, but you get anything from the other side of, how do I respond to this, or what are my rights in the situation, from an employee, with respect to an investigation that's going on. Either they're alleging it's a toxic kind of environment, or they may be the source of the toxicity themselves.
Go ahead, Sansia.
Yeah, so obviously on the employee side, it's very easy, and we kind of went over that. But on the employee side, yeah, sometimes they're the ones who are obviously going to be raising the complaint of toxic work environment. And before they go to HR, they may consult us and say, look, I one of the concerns that I have is reprisal. I'm afraid that if I tell my boss that, this is happening in the workplace or raise concerns about it, that I may get fired later, right? So obviously when they come to us for that type of advice, we'll get a quick summary from them, because sometimes clients, plaintiff and employer side, it doesn't really matter whether it's an employee, employer, they get things wrong, or they're so entrenched in their positions that they just don't see it, right? And, human beings, we all do that in different aspects of our lives, right? Or different arguments we're having, whether it's law or with a sibling or a family member, right? So you have to be able to kind of part the way or part the sea for them to say, look, I understand you see this as being a substantive problem, but it really isn't. So we do get a good chunk of employees who will come and raise certain things. And I tell them, look, it doesn't really quite fall under something that could be potentially legal, or something that you should really could even raise, that would fall into, like, let's say, toxic work environment or harassment in the workplace. And then there are ones that have some legitimate serious issues, like, for example, they've asked for accommodations in the workplace, right? So I've got an employee who's asked a very big company for several accommodations for a little over a year. They keep sort of dodging him and telling him, yes, we're looking into it. And, so he's got autism, and he's also got sensory neural hearing loss, so bilateral. And so that, in combination with the autism, really does affect and impact his ability to function. And so he's been seeking, for example, accommodations in the workplace. But there's also been an aspect of his case that involves some toxic work environment, because he's got a senior manager that's really been giving him a hard time. For example, when he's on a meeting like this, like a video conference, he needs closed captioning so that he's not missing things, because his obviously his medical challenges make it very difficult for him to be able to follow through on everything and process everything that happens during the meeting. And so he's got a manager that's been around the company for a very long time that seems to give him a bit of a hard time about transcription, purposely turns transcription off. We'll try to do meetings with him without his accommodations in place. And then you've got the employer at large who's also not fully facilitating that. So with a client like that, for example, they'll retain us on a per advice basis. So like, he'll set up various consultations and he'll say, okay, now I'm going through, like, for example, the short-term disability process. So Fahad and I never got into this, but we do also a lot of disability insurance work. And actually my prior background before getting into employment involved a lot of long-term disability claims, so which goes very well hand in hand into employment. And so, these clients that come to you, so the employees, you want to give them advice on what are their rights, what are their options. And sometimes I'll even frame the emails from them, but it won't be written from a lawyer, but it would have everything that's required to make sure it captures the duty to investigate, the duty to accommodate, right? These kinds of key things, so that it's documented. The client keeps asking for it. And then the second I have to get a litigation, I am ready, right? Because then we've got a nice, beautiful paper trail. And in this case, the client obviously has a huge medical history. So that's not even a concern. He's got a team of specialists, from SLPs, being speech language pathologists, to, ENTs. He's got a psychiatrist, psychologist that supports him. And so the employer in this case, eventually, I don't know, are they going to take the step to properly accommodate him? Is he going to have to claim a constructive dismissal? Or would they be that wild to just dismiss him? Because if they did, I would love it. But so, you try to advise the client on what are their rights, what are their options, what are the steps that they can take, and what they need to advocate. So you help them advocate without necessarily coming on board. Because, JP, a lot of clients, they're still scared of reprisal and being terminated. So they don't want to see someone like Fahad and I writing to the company they may need to work at for the next 5 years. So they want to try the easy way. So then the lawyer's sort of in the background advising them and telling them what their options are. And so in cases like this, for example, with his case, I was able to get him approved for STD, so short-term disability. So this was from November of last year until, well, today. He's still on short-term disability, while the employer is trying to figure out his return to work accommodation. So you can help these clients in all kinds of ways, from advice to how to report their complaints and whether their complaints are valid, to, okay, well, maybe you need a beyond accommodation of, let's say, headphones or closed captioning. Maybe it's you need to take some stress leave, right? So clients don't always know that. So you want to give them like the bucket of options, and then they need to get some advice from the medical practitioners to support that, because you need the support. I can tell them what's available, but without support, it really means nothing, right? I hope I captured everything. I'm sure I gave you more than you needed, but
No, it's great, and I think it's important. I think for anyone who's watching who may be interested in employment law, that there's being on both sides kind of gives you the other perspective as well. And I think we'll talk about it as well later. You have the third perspective that probably helps crystallize things when you go back and on the employer or employee side. But I did want to talk to Farhad a question about, you had mentioned doing a jury trial before we started. And how is that different than if it's a judge? That's any tips for litigators seasoned or brand new about what's different when you got 12 people hopefully listening to what you do and your client and all the testimony is going on versus that one judge. And I don't know if it's in person or online. Maybe you can also weave this in there, but how do you find doing things on Zoom versus in person, in light of those two challenges?
Well, let me preface this by saying that I'm not necessarily the most seasoned trial lawyer there. I've done about maybe 4 or 5 trials in my 8-year career. One was criminal, one was HRTO, one was at the labor board, and then a jury trial with a bunch of motions. So I've been fortunate that I've done trials in different arenas. The jury trial was a personal injury case. It was in person, and it was a great experience. It was 2 weeks. The first lesson I learned from it was, if you can settle a case, you should settle a case. We were on for the plaintiff. This was a minor car accident income loss claim. And before trial, we had offered 50,000 plus costs as an offer to settle. The defense offered 0. We ended up getting the guy, I think, 659, almost 600 grand. So when you factor in the 600 G's plus at least 200 grand, they had to pay their own lawyers. They spent almost $1 million on a case that could have gone away for 50, 60, 70, 80 grand, right? So that just shows you, no matter how confident you are in your case, don't ever get too confident, because you don't know what's going to happen. You really don't. So it was in person. And the jury trials are very different because they're very slow. So if you say the wrong word in front of a jury, the other side gets up. There's a whole, you mentioned the word insurance, and you can have a mistrial, and then the jury gets struck. There can be costs awarded against your client, sometimes against counsel personally. So you have to be very careful. You can't use emotive language. You stick to the facts. And the judge is still there. They control the process, but the jury makes a decision, and it's much slower. Like, imagine you have what, say 10, 15 days of trial. Every day there's an objection, something comes up, jury has to get up, they have to leave, you argue, they come back in, you got frequent breaks. So it moves much, much slower, but you get the decision right away. A regular judge alone trial, you might have to wait a year sometimes to get a result. Jury trials, you get it right away. And it's just a different experience. I mean, you're talking to people that look like you, that come from your background, that come from your community, and you make your pitch. So it was fantastic. Judge alone trials, you have a lot more discretion. You can be a bit looser. You don't have to worry about. It's faster in terms of the trial itself is much faster. So they're different beasts. With that said, JP, I think that they're trying to get rid of jury trials, at least for most cases, because it's just too slow. I'll give you an example. You need a bigger courtroom, number one, because you have members of the jury, you have counsel. So that alone is a big issue. Then you got to spend time finding jurors. That takes a day and a half. Then the whole process being so slow. So my gut tells me they're probably going to get rid of it for most cases, and maybe criminal will stay. But that's what I think is going to happen. But it was a fantastic experience.
Now, speaking of that, since we were also talking about you have a different hat you put on. I don't know how much percent of the time, but in an adjudicator role. And so how does that all work in terms of, today you can be litigating, an employee matter. Tomorrow you can be doing an employer investigation. And then next week, you can be sitting on a different tribunal as an adjudicator. So how do you kind of weave all that together? And I guess the second piece to that is, how does that work, wearing the different hats in all those other areas?
Right, so good questions, JP. I do my best to weave. So yes, I do sit, so just a little bit of background. I do sit on several tribunals in Ontario. I've got a lot of history, just doing some adjudicative functions. So I used to be a hearings officer for the Superior Court in the Central West region. I sat in about 8 courts there, all the way from Brampton to the Niagara region, Simcoe, Welland, that area. And then I've also been at the City of Toronto Administrative Penalty Tribunal, as well as the Condominium Tribunal, so the CAT. And then I've also sat at the License Appeal Tribunal, which is part of Tribunals Ontario. And so obviously I have not been able to keep all those roles. I've narrowed it down now to just 2 tribunals, being the City of Toronto one as well as the Condominium Tribunal, because practice has been quite busy. And you're right, it's hard to weave it all together. But what I will tell you is that having that experience, has certainly made me a stronger litigator and a better lawyer, because you see things from a completely different perspective. Prior to being an adjudicator or hearings officer, the roles are all interchangeable, but, I would just kind of put my stuff together, just try to get it out to the judge and hope that everything sticks, not paying attention to the clues or, what's happening and what does the judge really have to decide. But being an adjudicator, you're constantly processing evidence, framing issues, narrowing down issues. You hear lawyers make submissions to you about 80% of it being useless and thinking, why does it spend more time on the 20% that I'm interested in? So I can tell when a judge, or an adjudicator or tribunal is kind of losing interest, because that's not how they frame the issue. They don't see this as the problem. So I know quickly that I have to wrap that up before I lose them and move on to what the real issues are. And I feel like, with lawyers, we always have this worry that we may miss something. So let's just put it all in, right? But it's important to spoon feed and on some level. Give the adjudicator and judge, look at the issues and what do I need for that? Keep in mind, like Fahad's trial, he's in 2 weeks jury trial. How many times did that judge probably lose concentration, or probably was like, these guys are arguing about things that I don't really need to know at this point? So always try to do things like, I like it when lawyers, for example, appear before me and they'll say, okay, so, Adjudicator Pinto, I understand that you've heard a lot of things today. However, I wanted you to take away X, Y, Z. Give me the takeaway. If you're going to give me 10 cases, you better point to what you think is important about that. Tell me why each and everything you're submitting to me is important. And that's something I use when I practice as a lawyer. So if I'm going to submit something, it's either going to be highlighted, it's going to be flagged, or I'm going to be telling the judge or adjudicator why I've submitted this and which parts of it are important. Because the cleaner and easier I make it for them to follow, the more likely they are to follow my argument and then be able to make a proper ruling. Instead of just sticking everything at them and then they're trying to figure out timelines or what's going on. Because lawyers sometimes, when they present their submissions, JP, they don't do it in a chronological fashion. And they forget that the person sitting at that top there has no idea, knows nothing about this case. So you need to walk them through the steps, right? So having that adjudicative background is really, really helpful. Obviously I enjoy it. It's a different aspect of, that I get to explore my law degree in a different way. Aside from adjudicative work, I also do mediation work. And so I did get my mediation certificate in Harvard, and they do mediations very differently over there. They do open style mediations. And so I try to employ both. And I think between the lawyer training, the mediation training, and the adjudicative training, it's made me a much better lawyer. I may not be the best out there, but I definitely feel that I'm better after all these experiences than I was before them. So I think there's a wealth of experience that you can get by doing, whether it's mediation type work or adjudicative type work. But if you're going to be a litigator, I think having that experience of kind of knowing what the person has to decide is sort of looking for and interested in, it makes it a lot easier for you when you're counsel to be able to present that in a much better fashion.
JP, one of my former bosses, very well-respected guys, 40 years of litigation. He said to me one day, he's like, judges look to do what feels fair. Most judges look to do what feels fair to them, and the law is just a vehicle to justify the result. And that really stuck with me because, again, I don't have Sansa's experience, but I can imagine if you're sitting up there and you have two competing narratives, I would imagine that fairness and equity would be a very important factor in your mind. And then you look at the law and see how that can be used as a vehicle to justify your conclusion. I mean, Sansa, correct me if I'm wrong, but is that fair?
That's absolutely it. And most adjudicators will tell you that, right? So counsel can submit all these things to you, but when I'm writing that decision, JP, I sit there and I say, okay, here's what the law says, but I want to use also just some of my training, understanding, experience, and also to look at what is fair. What is fair and reasonable in the circumstances? Once I arrive at that, then the law supports that. And that's how the decision gets written, right? So, I feel like lawyers have to remember that and convey that, right? Because ultimately, that's how the decision makers are making the decision. That's why case law gets changed all the time. That's why the employment world has changed so much. It's based on fairness, what seems reasonable, right? And then applying the law to get to that, right? So I'm very appreciative of being able to be appointed as well as having the opportunity to sit on these tribunals because it has made a much better litigator. And I also see things very differently than I did when I first started practice. So it's a great opportunity for anyone considering it.
Yeah, and since one of the other things that you mentioned is, with the LPP that you kind of give some guidance to students as they transition, from students into, articles and then lawyers. Anything there in terms of that diverse background, right? In terms of mediation as well, adjudication, and then litigation and varied litigation of, getting into these things and how it helps, go from, I mean, I don't know how it is. I actually had this conversation with some other lawyers earlier today about, how practical is the legal education, in terms of, if you have an employment course, are you just, learning, uh, the trilogy of cases and theory, but like how much of it is, knowing what those Bardell factors are in practice, versus, here again, the varied experience you have, how can students benefit from, taking those next steps, before they go out and practicing?
Yeah, so that's actually a very great point. I'm happy you raised it. So, yes, I do teach at the LPP Ryerson program where I'm an assessor and mentor for their program. I've been doing it for the last few years and I absolutely love it. And I love dealing with the candidates. They're a fantastic bunch. What I will tell you is that, going to law school, and we can all sort of attest to it, you get a lot of the theory and the practical component sort of gets lost. And what I like about the LPP program, because look, with traditional articling, it really depends on where you end up. One firm can do articling completely different than another firm. So at one firm, you may be research memoing whole term, barely get client interaction, barely get in a courtroom. But with something like the LPP Ryerson program, it's just, it's tailored to make sure that you touch different areas of law, but you also get lots of practical training. So practical in the sense of you do examinations for discovery. They do a full Zoom trial from start to finish, direct exam, cross exam, all of that. And I assess them based on obviously their performances. And one thing I always get, so at the end of a term, you always get feedback from the various students that you coached or mentored or assessed. And the one thing that most of them always say is that they love the practical experience I bring to the teaching. So when we have like our weekly sessions, I don't go into, let's say it's professionalism topics. I tell them to present the topic to me, and then I give them the practicality of how this applies. I give them the scenario. I tell them about the crazy cases where I've gone to discoveries and counsel is leaping across the table, right? Things to make so that they can kind of mesh that with the rules and the theory of things that we're learning, right? So I find that most candidates and students, they certainly appreciate obviously learning the theory and the cases and the Bardell factors, but giving them that practical example helps stick with them longer, and it helps them relate to the material they're learning. So I do think it's a big part. And I wish obviously that the schools did it a little bit more often. Because you know what, at the end of the day, you're going to leave law school, you're going to be out on your own, and then lawyers are kind of feel bamboozled, and you'll speak to a lot of new calls, and they'll say, well, I don't know anything about billing, right? So, for example, because I was an assessment officer, like the students that I in part of my group, they always know how to bill because I this is something I put a lot of emphasis on because law school doesn't really teach you about billing, and a good part of practice in any firm that you're at is going to want to make sure that you know how to bill properly and fairly, right? So these sorts of practical experiences are really, really important. And so, you do what you can to try and send that home with the candidates and the students so that it allows them to be successful when they either finish the LPP program or they finish articles. But it's certainly a big part. And I feel that sometimes law schools sort of miss that boat without offering more price. It's not that they don't offer any, I just think they need to do more because that goes a long way with candidates and students who are going to be coming out as new calls are going to feel better prepared.
And Farhad, I mean, it's similar in terms of practical knowledge that students may not get. Either paralegal students, law students, is what it's like, the day to day, in your own firm, right? I mean, I don't know, maybe you could tell me how much percent is lawyering, and how much percent is doing other things. Now you mentioned how to bill, Sensei mentioned how to bill, but like even like connecting, right? I mean, networking, right? How do you get your clients? How do you discuss, with other lawyers? Here's what's going on. So what can you share, Farhad, about kind of all of those things, in having your practice here, your firm, that you don't learn in school about sort of the non-lawyer work, that you have to do, especially with your own practice?
Well, to be honest with you, you don't learn it at for other firms either, right? So, I was fortunate enough to article at a big Bay Street firm. Then I opted out of higher back and went to a couple of mid-sized firms. I've worked with some fantastic lawyers. I'm very grateful. But having started my own practice, I would say the actual law side is like about 30 to 30, 40% of what I do. The other 60% is running a business. And that's the most important distinction for me. I'm 8 years out, I think, 8 or 9, no, 8. And running a business is so different than being a lawyer. I mean, the business of law and the practice of law are two very different skill sets, and you have to learn both if you want to do well. What shocked me was meeting lawyers who some are making 7 figures, some are making close to it, and they don't touch files. They just run a business, they market, they bring the work down, they bring the work in and they delegate the work down to others. So I realized you don't even have to be a practicing lawyer to make to make great money, running a business. So, but for us, we take pride in actually doing the work as well. So most of our clients, all of our clients, they get us when they retain us, and we work with them very closely. But the business of law is very different. It's very challenging. So a big chunk of my time is spent meeting people. In a day, I'll have 3 meetings lined up. Some will be Zoom meetings, some will be lunches, some will be coffees, and that's how you get good quality work. Some people put a lot of money into online marketing, and that can work as well. But the best work, and our work comes from referrals. We spend a lot of time building relationships with existing clients, with potential clients, with other lawyers. Spend a lot of time, meeting people. It's almost like being a politician. You got to get out there. You got to advocate for yourself, advocate for your services. So very, very important. If you want to do this and run your own shop, you're going to have to spend a lot of time meeting people, a lot of time building relationships, and then doing good work, because that's ultimately what matters. And so we're very fortunate that we get a lot of referrals from existing clients, and from people we trust. So.
Perfect. So Farhad and Sansia, thank you both so much for taking the time speaking with me, speaking to my students and anyone else listening. So last question, and I'll go to you, Farhad. First, any final words of wisdom for any of the students? And I know you just both shared some great advice there, that you'd like to leave with. And thanks again for joining.
Yeah, sure. I mean, I think it's very important to, just ask yourself what you want from your career. If you want to stay in private practice and that's something you value from a very young age, from the beginning of your career, start thinking about business development. Start thinking about, you know, ultimately, even if you want to stay in a firm or become partner, the way you really add value is by having a book of business. So as a young lawyer, you should try to go to as many of these networking events as you can, maintain and build relationships with your friends from law school, and your peers at the bar, and always think about not just doing good work, but also potentially generating work. That is what will set you up for a successful career long term.
And Sansia, I guess anything you'd like to add, from all your experiences that you haven't mentioned already about any parting words for any of the students or anyone else listening?
Yeah, so JP, just a couple of things. I would say one, to students, lawyers, new calls, doesn't matter. Take initiative. Take initiative and make the experience whatever you want it to be. So if you're a new call and you're articling at a firm and you find, hey, they just keep giving me research, go through every lawyer's calendar in that firm. Take a look at what they have scheduled. Piggyback on all of it. You see that they have mediations, trials, whatever it is. Sometimes opportunities aren't just going to show up on a silver platter. You create them by reaching out to the lawyer and saying, hey, I see that you've got this mediation on this date. Do you think I could assist with the first draft of the brief? Or if you don't think I could do that, do you think I could just attend to shadow? Because you have to create some of these opportunities, because at many of these firms, it's not that they don't want to give you the experience. Sometimes they get busy. The lawyers are so tunnel vision and whatever stress they're dealing with, they forget to bring the student along or the new call around, to get that sort of experience. So take the initiative, create what you want to do, right? Whatever you want that experience to be, take a hold of it and go ahead and reach out to various counsel in your firm and say, I'd like to attend this, or I'd like that, or I'd like to do more work in this area. Is there an opportunity to do that, right? Because if you don't take that initiative, I think it sets you up for, usually an experience that people later down the road say, I didn't have the best articling experience, or the best first years of my life were just basically researching. I never got to meet clients. Ask, ask. Worst case, they say no. Ask the next lawyer and keep asking until you get the yes, right? So that would be my first piece of advice. My last piece would be, you know, lawyers, we always kind of worried when we first come out as to areas of practices we go into. Are we pigeonholing ourselves? How do I switch areas? They're all transferable skills. You have a law degree. That's pretty damn amazing. And people have to remember that because it opens so many doors. You could be a hearings officer, you could be an adjudicator, you could be a mediator, you could be a litigator, or you could be the CEO of some company. So never think that you have to do anything traditional with your law degree. And if that's what you want to do, you just want to get the law degree, be a lawyer, be a litigator, that's great. But always think outside the box, because if you are not happy for some reason because law school sold you some idea and then practice was completely different, that's okay. Take that law degree and figure out a way to sell it to get into a nonprofit, become a CEO somewhere. There's lots of opportunities. You literally have your foot in. You just have to decide which path you want to take. Maybe you can even change paths, right? Just be able to sell that dream. I think you can do it. So that would be my advice.
Perfect. So thank you both again for taking the time and joining us, and thanks for everyone for listening. All the best and take care.
Thank you.
Thank you. Thanks for having us.